And welcome. Welcome to the show tonight. Let's make sure everyone can hear me and we'll get started. All right, how's everybody doing? Boom, we're on a Tuesday, a big old Tuesday, January 21st. For those on the replay, who knows when it is, but welcome to the show. We will be talking about a few things tonight, and I want to welcome everyone who is here. Hope you're staying warm. We're in the middle of an Arctic plunge, a deep freeze. And we haven't been above freezing for quite a while, but maybe you have, maybe you haven't. But we hope you're all staying warm. And anyway, while you're coming in, go ahead, hit the like. Everyone who's in the Lurker crew, go ahead and join the live chat. I would appreciate that. And so would our chatters. And we'll get started. First of all, let me say hello to everyone who was here early. And that includes Sarah, Imagine, who became a new member. Thank you for the membership, and that's going to be important. I'm going to tell you why shortly. But welcome, Imagine, to the memberships. And Fur Baby Daddy, Elizabeth Jones, Say What, Plain Iron, 26 Dead Zombies, Nancy Drew 101, Marianne, Pam Sheehan, Big JD, Deputy Dog, Don McKenzie, Beautiful Amy with the flowers, Oleg Cat, Rhonda Holton, Judith Galloway, Deputy Dog, Who's Your Daddy, Christopher, Kenneth, Mark Ellis, Scales of Injustice, Scales of Injustice, okay, Deb, Sweet Dude Shibby, Bully Graphics. Who else we got in here? Gretchen Allen, Rebecca Ann, 1965, Brenda Mays, Monday, Cinnamon Apple, Tracy Thornton, Mandy Gilliand, Mama Bear 2222, Elizabeth Jones. Right, what's up, guys? Jamie Blair, Tony Hunt. Okay, Lisa, Sunflower Soul, Bonnie, Mary Martin. What's up, all of y'all? Christopher, first time listener, welcome to you. Kayla, what's up, Kayla? Crystal Blue Persuasion, what's up? Trial Junkie, what's up? And Mama J, Donnie Pitbull Kuntz. I think that's everyone so far. And hopefully more will be joining. Who knows where they are? Scattered all around the E-verse, the universe. Um, that one dude 75, what's up? And good evening to you. Yeah, please hit the like and let's do a little chat. Okay, so tonight we will be looking at the plethora of filings um from the defense, and that should be interesting. And some of you may or may not be interested to hear, but you may not be happy to hear. But I will be laughing at some of you, and some of you I won't. And please don't take it personally. I just laugh at what I think are absolutely ridiculous ideas. For instance, the idea that Ron Logan killed Abby and Libby is absolutely fucking fanatical. But but that doesn't mean that he didn't have knowledge of what happened. Anyway, that's my take on that. But I'm sorry if you're offended by that. Oh, I'm so sorry. And there'll be other things that will offend you, I am sure. Uh, V, what's up, V? And Keith, what's up? Coming in, all right, a little tardy. Um, but we will be looking at these filings, and it will sort of be a displaying for you all of that material. So, hey, if you already know it, if you don't want to care about my opinion, just leave. I don't care. Uh, but if you like my opinion or my take on it and my commentary, then stick around, stay. We'll be looking at the information, and I'll be giving you my take on it, and um, and that's that. And so that's how we'll be starting. Welcome Four Pits, welcome Plain Iron, Mino Dino, mm, Teresa, Heather Brown. All right. All right. So um, I called tonight's show, though, oddly enough, Flamethrowing the Delphi BS, including the idea that Ron Logan killed the girl. So, yeah, we'll be flamethrowing the entire community. So, hope you're ready to be mad at me. Obviously, it's a common occurrence with me. I'm sort of getting used to it. What's up, sweet and salty? Welcome to you. All right. Um, but you are all welcome here, regardless. Um, but we do have some announcements of sort. Welcome, Bella's in Wonderland. Um, so there are going to be some changes to the channel in some ways. Um, I'm going to be making an effort uh, to 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 fully step this into a new direction and into a better direction and into a professional direction. So we'll be my goal at this point is that we'll be doing shorter shows. We'll be doing uh, a schedule now. So what I'm hoping is now will be 9 Eastern every night. Okay, 9 Eastern on weeknights with a shorter show, and on Wednesdays we'll do members only chats. So for all you members, the chat will turn to members only for Wednesdays to give you something special, and um, and I'm also hoping that as part of this, we're able to get a little more support for the channel and step it up to another level because there are some since the trial is ended, the support for the channel financially has fallen off, and I think that part of that is that this has been a very narrow focus, and that's been good and all, but the news is slowing down, and I think that what you'll also be seeing is I'm going to be broadening the subject matter and the information and the areas of interest because that's also important. I made a decision to move in a particular direction, and so we'll be going that way. There's going to be lots of precipitous changes in our world in the near future as the future progresses, and I think that it's important that I can add my own way to help us all navigate that terrain. Um, but let me also say hi to Don't Tase Me, Laura Naran, Ninja Warrior Assassin, Lisa. All right. Yeah, so you see, Nancy Drew has our scripture for the evening up here. It only gets worse. The Prop 121. Uh, but I welcome you all here. I'm glad all of you lurking. Feel free to lurk, but I would love for you to join the chat, and so would our subscribers. And not to really be announcing too many changes, but I'm also going to be expanding into other platforms, okay? Because I have purposefully uh, focused on exclusively remaining in YouTube. But I think it's important at this time that I broaden out and probably going to put ourselves on Rumble and on Twitch and on TikTok and on uh, Twitter a little more actively. So in all those ways, as you see. Um, anyway, that be what it may. I welcome all of you here, and that's what we'll be doing. Just a moment, please. All right, so not sure what's going on, but we're going to keep plugging forward. Um, let's see. Um, now we got some things to get into, so here we go. All right, now, as I mentioned, if you don't care, move on. We're going to get into this. Wow, wow, wow. So, this is our motion to correct errors. Don't worry if you've already used your addiction to fulfill yourself in on this. That's fine. That's fine. Okay. Now, there are some interesting things in here and some not so interesting things in here. So, I guess I'll approach it from that angle. Okay. Now, first and foremost, and most importantly, it is truly my opinion that this is the absolute most important thing that has happened. Okay. Um, I'll just continue. Mhm. So, what this is, it says, in violation of the Sixth and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding, November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel. All right. Mr. Allen was prejudiced by being unrepresented by counsel during that proceeding. Here, there's a quotation of Indiana Code 353311-1, which governs safekeeping proceedings for pretrial detainees. Okay. Upon motion by the sheriff, prosecuting attorney, defendant, or his counsel, attorney general, or court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. If the court finds that the inmate is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or to a facility of the Department of Correction designated by the commissioner of the department, which is what happened with Richard Allen, as suitable for the confinement of that prisoner and provided that space is available. For the purpose of this chapter, an inmate is not considered in danger of serious bodily injury or death due to an illness or other medical condition. And it says that Indiana Code 353311-2 also governs safekeeping proceedings for pretrial detainees and provides in full. The inmate or receiving authority is entitled to a post transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety? Now, let me remove that for a moment. I'm no lawyer, right? I'm a reader. But as I've looked into this and spoken with some attorneys, I'm telling you now that this is a major, major issue. As I've mentioned already, the number one issue we'll be discussing today. And oddly enough, it just falls right in line with the unbelievable malpractice that we've seen in this case. I mean, and I see, I'm so glad that our sweetheart Nancy Drew 101 came in and made the little snarky comment because she's right that it only gets worse. And it's, I guess I used to love to say shack attack. Okay. But at this point, it's pointless to say shack attack because the truth is that it just only gets worse. You know, when we're reviewing all the occurrences or happenings that have occurred in this case. Um, did I lose her little snark? Oh, maybe I did, but it was worth putting back up. Let me find it. Oh well, I give up on Nancy Drew. I've lost her. Okay, I've lost it. um, the Shack Attack days are still golden. Yeah, I wish I had that whole. Listen, I got so derailed and upset by the troll farm and all that has happened that my joy was stolen. Okay, the joy of doing that was stolen. Uh, all fun and games ended because it was not worth. It was not worth. It was not worth it. But let's continue. But as I'm saying, this is an absolute just it's unbelievable. Mr. Allen was interrogated and immediately arrested on October 26, 2022 by Jerry Holman and booked into the Carroll County Jail under a pseudonym. Oh, don't worry, we'll be getting to that later. The next day, okay, the next day, October 27, 2022, Kathy Allen, Mr. Allen's wife, hired an attorney, Brett Gibson, to represent Mr. Allen. Okay. Exhibit one. Exhibit one. So let's throw the receipts in the faces. Okay. Thank you, Nancy Drew. There you go. It only gets worse. Now let's look at this. Let's take a little detour here. Going to take a little detour. Going to take a look at this. It says the affiant Kathy Allen, upon her oath under penalty for perjury, says, I am Richard Allen's wife. On October 26, 2022, my husband was interrogated, arrested, and jailed. The next day, October 27th, 2022, I paid Brett Gibson, a lawyer in Lafayette, Indiana, $5,000 to represent my husband. Exhibit 1A is an email I received from Mr. Gibson's office acknowledging that I had paid Mr. Gibson to represent my husband. The evening of October 27, 2022, Mr. Gibson sent a letter by email to the Carroll County Sheriff and Nicholas McLeland, the Carroll County prosecutor, telling him he was representing my husband and they should cease all questioning of him. All right. So let's look at these things. Exhibit 1A, payment receipt, $5,000. Exhibit 1B, October 27th, 2022, Carroll County Sheriff, 310 West Main, Delphi, Indiana, in reference to Richard M. Allen. Dear Administrator, please be advised that I have been retained to represent Richard M. Allen in certain matters relating to an investigation being conducted by your office, by the Carroll County Sheriff's. It is my understanding that my client is being detained by Carroll County Sheriff. He will not be giving any statements regarding this matter. If he is currently being questioned, the interview should be terminated. If you have any comments or questions, please do not hesitate to contact me. I can be reached by email. Thank you. Okay. CC, Carroll County Jailer, Nicholas McClelland. Is there any question about what that is? All right. Back to this. About 10 p.m., Mr. Gibson called me to say he would not be able to get my husband out of jail because he was going to be charged with murking the next day. Okay. What emerges from defendants exhibits 1C and 1D is the following. Sheriff Lesenby confirmed receipt of Mr. Gibson's letter by telephone the evening of October 27th. However, over the telephone, someone at Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McLeland by email, after which Mr. McLeland called Mr. Gibson on his cell phone. Mr. McLeland told Mr. Gibson that Mr. Allen was listed at the jail under a different name alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson that the regular jail staff did not know Mr. Allen was there. Still, on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss this case over the telephone because calls would certainly be recorded. Okay? Are we keeping up? Are we keeping up yet? Are we keeping up? So, Gibson goes to meet Mr. Allen on the 27th. In the evening, about 10 p.m. on the 27th, Mr. Gibson called Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murking the next day. Exhibit 1. On October 28th, without Mr. Gibson present, even though McClellan and Sheriff Lesenby both well knew Mr. Allen was being represented by Mr. Gibson, Mr. Allen was charged with 2 counts of murder, and Judge Diener held Mr. Allen's initial hearing. Who cannot claim ignorance of his representation by Mr. Gibson? See, this is going to be an interesting chess game. Keep in mind who our judge is, so obviously she's going to just sway it her way, but defendants exhibit 1C says the affiant Brad Rossi, upon his oath under penalty of perjury, says, I am a lawyer with a law practice in Logansport, Indiana, and have been a lawyer in good standing in Indiana since I was admitted to the Indiana bar June 7, 2002. Since November of 2022, I've been the attorney for Richard Allen, who is defendant under this cause number. In an attempt to learn whether Richard Allen's first attorney, Brett Gibson, had communicated with either prosecutor Nick McLeland or then Sheriff Tobe Lesenby or any other law enforcement officer concerning the fact that he, Mr. Gibson, was representing Richard Allen, effective October 26, 2022, I reached out to Brett Gibson via email, asking him a series of questions. The purpose of my inquiry was to determine whether McLeland, Lesenby, or any other law enforcement officer were aware that beginning on October 26, 2022, attorney Brett Gibson was representing Richard Allen after his arrest on October 26, 2022. Attorney Gibson responded to my email inquiry and indicated that indeed Richard Allen had retained attorney Gibson following Richard Allen's October 26, 2022 arrest. A copy of said email, which is marked as Defendant's Exhibit 1D, is incorporated into this affidavit. Furthermore, in his email response, Attorney Gibson stated that he, Attorney Gibson, communicated with Nick McLeland both by email and by cell phone and alerted McLeland that he, Mr. Gibson, was in fact Richard Allen's attorney. Furthermore, in his email response, Attorney Gibson stated that that Prosecutor McLeland helped arrange a meeting between Attorney Gibson and Richard Allen at the Carroll County Sheriff's Office, and that said meeting did in fact take place between Richard Allen and Attorney Gibson, and that furthermore, Attorney Gibson advised Allen not to discuss his case over the phone. I have attempted to gain Attorney Gibson's affidavit concerning the things he states in the email, Exhibit 1D, but have been unable to at this time. Okay. So what are we talking about here? Well, let's take a look at this. This is from Brett Gibson, attorney Brett Gibson to Brad Rossi, attorney Brad Rossi, January 19. Hi, Brad. Attached is a letter I sent to the Carroll County Sheriff's Office and an email I sent to Nick McClellan on October 27th, 2022, regarding your question. Did you ever communicate in any way with the prosecutor or law enforcement officials before Richard's arrest? No. Did you ever communicate in any way with the prosecutor or law enforcement officials after Richard's arrest? Yes. It says, on October 27th, 2022, Kathy Allen notified me that Richard had been arrested. We sent a letter to the Carroll County Sheriff notifying them of my representation. The sheriff confirmed receipt over the phone. However, the jail advised that Richard was not an inmate. I contacted prosecutor Nick McClellan by email. He called me on my cell phone afterwards. He advised me that Richard Allen was in the Carroll County Jail and they had him listed under a different name, alias. He arranged for me to meet Richard at the jail that evening. Someone from the sheriff's office took me to a meeting room in the jail. It appeared that regular jail staff did not know Richard was there. Let me know if you have any questions. Brett Gibson, attorney, Gibson Law Office. From Brad Rossi to Brett Gibson, January 19, later in the day. Nick, I have been retained to represent Richard Allen. His wife, Kathy Allen, advised me that Richard was detained by the Carroll County Sheriff's Office yesterday. She said he has not been released. However, I called the jail and they told me that he is not there. Do you know Richard's whereabouts? Is he in police custody? I want to confirm any interrogation is halted. Thank you in advance for any feedback. And that's from Brett Gibson to Nick McClellan, Thursday, October 27th at 6:36 p.m. From Gibson Law Office, Miss Ann Dean Dam, Thursday, October 27th, to Carroll County Sheriff's Office Jailer, to Carroll County Prosecutor Nick McClellan, CC Mr. Brett Gibson. Correspondence from Gibson Law Office. Please find the attached correspondence. Okay. Now, oh man, let's see. After his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. The letter and envelope are part of the record in this case. In that letter, Mr. Allen requested that court appoint counsel for him. Nothing in the letter indicated he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there and is shown filed in this court on November 9, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1st, 2022, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognized by the U.S. Supreme Court in Houston v. Lack, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. All right, let's bring me back for a minute. Do you understand this litany or sequence of events so far? Listen, I'm not trying to be rude here. When you're having audio problems, please just turn the shit off, turn it back on, and try again instead of bothering me in the chat about it. Okay, because you're distracting me with problems that are non existent that may be on your end. So just close your app, restart your phone, whatever you got to do. But listen, going back to what's important here. Where is it? So Kathy Allen pays Mr. Gibson to represent Richard Allen. There's no question about it. Mr. Gibson immediately starts to work that out. Okay. Are you gonna, listen, if you're having a problem with your computer and you're distracting me in the chat, I'm going to block you. Um, Jesus Christ, man, you make this impossible to do. It's already difficult. The safekeeping proceeding was plainly illegal from start to finish. First, Sheriff Lesenby transferred Mr. Allen to the White County Jail on October 28th, 2022, with no safekeeping order in place. Next, Sheriff Lesenby had no standing to make the safekeeping request on November 3rd due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28th. Once Mr. Allen was in the White County Jail, the White County Sheriff was the sheriff statutorily authorized to make a safekeeping request under Indiana Code 353311-1. Because Sheriff Lesenby had no standing to make the safekeeping request, Judge Diener has no jurisdiction. Okay. So, like, I'm just trying to have you understand that I cannot make the chat go away so that I don't see it. Can we please focus on what's important here? Like, Jesus Christ, man. What's important? There are a few things important here. And these things have, do you see them piling up? So let's backtrack a bit because I'm having so much problem even maintaining a coherent thought with this fucking problem here. Listen. Allen retains counsel via Kathy Allen on October 27th. You've seen the receipts for that. McLeland and the sheriff are very well aware of Mr. Gibson representing Mr. Allen at this point. Is there any question about that? There should be no question about that. Mr. Gibson even goes to meet with Mr. Allen. All right, at the Carroll County Jail. McLeland is aware of all that's happening. Lesenby is aware of all that's happening. The next day, October 28th, knowing that Mr. Gibson is representing Mr. Allen has counsel. Without Mr. Gibson present, they have a hearing. Mr. Allen is charged with the 2 counts. Who's presiding? Was Judge Diener. Without a safekeeping order and without a hearing for a safekeeping order, and without an attorney for either of those situations, for the charging or the safekeeping, he's transferred to White County. Lesenby transfers him there to White County, and next, and then in between that moment, once he gets to White County, he writes his letter for appointment of counsel. Then on November 3rd, Sheriff Lesenby, without jurisdiction, requests a safekeeping, and Judge Diener had no jurisdiction to issue the safekeeping. So Lesenby has no jurisdiction because Allen is currently in White County. Okay, so Lesenby is not the sheriff. He doesn't have standing. Diener has no jurisdiction. Do you see the series of events that are unfolding that are one misstep after another. All right. Let's bring this document back so I can actually focus on what I'm looking at. Okay, I told you, like, and the reason I'm kind of being upset about how distracting this has been is that this is the most important. Like, usually the shows, usually when I do a show, it gets more important later in the show. We get into more severe. This is actually the most important part of the show right now. Okay. This is the point I'm making. This is the most important part. This is the most significant thing that we will be discussing. This is the most grievous error or series of errors. It's probably the thing that's going to have some teeth. We should be focusing on this. This is important. Okay, so Mr. Gibson. So where are we? We're at Mr. Gibson's representing Alan. Alan's being held under an alias or another name. Lesenby and McClellan are aware that Alan is being represented. They don't care. They do what they want the next day anyway. Okay. They then move him to White County, where he's in another jurisdiction. Yet they still do what they want to do without jurisdiction. Okay. And we're talking about Diener, Lesenby, McClellan. Second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lesenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lesenby, helping Sheriff Lesenby draft his safekeeping request, which is in violation of Rule 310 of the Code of Judicial Conduct. Rule 310 prohibits judges from drafting or reviewing documents except for family members. Oh, I'm supposed to be reading this. Okay, let's put it back. Let me read it again, because I think you may not understand. I think you may not understand. Mr. Allen had a right to have a judge other than Diener decide the safekeeping order that Lesenby made without jurisdiction or without standing, because Diener engaged in ex parte communications with Lesenby, helping to draft the said safekeeping request, which violated Rule 310 of Code of Judicial Conduct, which prohibits judges from drafting or reviewing documents. Judge Diener also violated Rule 2.9 of the Code by engaging in substantive ex parte communications with Lesenby, which helping Lesenby draft the safekeeping order were. Having violated both 2.9 and 3.10, Judge Diener was obligated under Rule 2.11 of the Code to recuse himself and request appointment of a special judge before he issued or before a safekeeping order was issued. Okay. Does it make sense now? Why? Do you remember how we always questioned, why in the world would Diener step down? Remember that? We've always we've gone over, and I've gone over the bloodlust. If you go back into my channel, which please, I ask that you do. And actually, I'll pin it here for you guys. Let's see. Because I have one called Bloodlust, in which I go into detail into Judge Diener, right? And his whole recusal and all the whole deal. So let's put that up for you, especially those of you who are new. Sorry. Those of you who are new and you haven't seen it, please know that this exists right here that you can go back and watch, okay? So I'll just put that there. That one's called Bloodlust. I go into Judge Diener and the whole deal. Okay, so now back to this. It gets worse. Like Nancy Drew says, it gets worse. Third, Sheriff Lesenby, in his November 3rd, 2022 request by the Sheriff of Carroll County to transfer an inmate from custody of the sheriff to custody of the Indiana DOC for safekeeping, was not served on anyone. There's no certificate of service attached. Indiana Code 353311.1 requires a safekeeping request to be made by motion. Indiana Trial Rules 5A, 2, and 3 require that Sheriff Lesenby's motion for a safekeeping order be served on the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for a safekeeping order. If he claims Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lesenby was required to then serve Mr. Allen personally. Are you seeing the layers here? Fourth, Sheriff Lesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by Indiana Code 353311.1 that would authorize a safekeeping order. Fifth, because a factual finding was required to authorize the safekeeping order, a hearing with notice to the parties on Sheriff Lesenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the DOC. Sheriff Lesenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for the safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer. Now, let's go back, okay? Let's go back to the very first or second page here. It's going to be, I believe it's page 3. Look at the top there. There we go. It's 353311.2, post-transfer hearing, right of inmate to refuse transfer. The inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety. All right. Mr. Allen had no opportunity to exercise his rights. Do you understand? Like when we're going back to the 6th and 14th Amendment violations here. This is why I'm saying this is an absolute this is the most important, in my opinion, this is the most important aspect of any of these drops in the past 48 hours. All of this shit, and you're going to have the entire troll farm, trust me, that like it's already happened, okay? The entire troll farm is going to be running their fucking fat mouths about this, that, and the other, blah, 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 blowing things out of proportion, distracting, All that they do, okay, for disinformation, misinformation, distraction, division, gaslighting. You need to keep in mind the number one thing is the safekeeping order and the retainment of Mr. Gibson that was ignored. Okay, all of this we've just read in these first 6 pages. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana DOC, where, and keep in mind how substantial this is. This is substantial because this is where he ended up being tortured for over a year, subjected to solitary confinement, okay, tortured in an effort to force him to plea, threatened with death, his family threatened with death. You understand? Both by inmates and by other and by guards, trying to force him to plea. Tortured. He had a right to have an attorney assist him in refusing that placement in that environment where he was tortured, where he was threatened, where he was squeezed in an attempt to coerce this plea out of him. And as I mentioned before, that effort failed. But what it did produce was the fruit of these coerced confessions due to the prodding of Dr. Manakawala. So if you look at this in hindsight, this is absolutely a crucial moment in time, going back to October 27th through the period to November 3rd. This set into motion all of the subsequent events that led ultimately to his prosecution, because you should be very well aware that if it were not for his coerced confessions made under duress, he would have not been convicted. We've already had the juror enlighten us as to the fact that they had disregarded that ballistic evidence because it was garbage. They had disregarded Sarah Carbaugh's quote unquote testimony because it was garbage and she was clearly lying and combative. All you had left was the weight or the subconscious effect of those alleged confessions, which are substantive, because if it were not for his illegal detainment in Westville, for his safekeeping, a hearing without his attorney that both McClellan, Lesenby, and I'm sure others in this whole process knew about, it's major, in my opinion. Again, I'm just a reader. You know, all I do is read. Okay. Where are we here? We're reading. Okay. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana DOC custody or to make any of the objections set out above to the entire course of the proceeding. That's for quite a simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, who Kathy Allen paid $5,000 for, had no notice of the legal skullduggery or bullshit that would land him in solitary confinement at the Westville Control Unit, Wabash Valley Correctional Facility, and Cass County for 23 months pending trial. Because Mr. Allen had no notice of what was happening to him, right? Neither he or his lawyer could make any of the arguments that would necessarily may have prevented him from being placed into those environments. I hope that's absolutely clear. And I almost feel like I have to go back and say it again. I really do. I do have to go back and say it again because it's worth saying it again. Mr. Allen had no opportunity to exercise his constitutional rights, both under the U.S. and Indiana constitutions, to refuse or reject the transfer for his own safekeeping to the Indiana DOC, his own safekeeping, or to make any of the objections above that we've just gone through. Allen or Mr. Gibson had no notice of all of this BS that would land him in solitary confinement at Westville and Cass County for 23 months. 23 months. And as I've mentioned, it's these environments which produced his conviction. Yes, it is. Because Mr. Allen had no notice of what was going on, neither he nor his lawyer could make any arguments that would have prevented his transfer. Finally, Mr. Allen's own absence from the safekeeping proceeding should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standards as trained lawyers. One consequence of this should be that the Sixth Amendment and Article 1, Section 13A of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of a criminal prosecution. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyers interpose all the objections to the November 3rd safekeeping order. A critical stage is one holding significant consequences for the accused. I almost said, wow, that's amazing how God works. I almost said abused. Actually, I wish I would have just not bit my tongue. A critical stage is one holding a significant consequence for the abused. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume that Mr. Allen was prejudiced by the deprivation of counsel. Alternatively, Article 1, Section 13A of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. Section 13A affords citizens greater protection than its federal counterpoint, Caraway v. State. Not only does Section 13A guarantee criminal defendants the right to counsel at any critical stage of the prosecution, but the right or the rights afforded under Section 13 also attach prior to the filings of formal charges, which means they go back to October 26th. The court need not speculate whether safekeeping proceedings have serious consequences for an accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconstitutionally kept in solitary confinement in an Indiana DOC prison, shackled, leashed, hooded, deprived of human contact, which altogether are violation of due process for pretrial detainees. Okay, as a consequence of that torturous environment, and that torture, Mr. Allen became psychotic. Now, short of his death, it's hard to imagine any more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceeding, not to mention the fact that it is the very abuse and threats and neglect that he received over in this safekeeping environment, which coerced those confessions out of him, which were ultimately used against him in the court of law. Do you see how bad this is? All right. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. This should be particularly disturbing because had he been given the opportunity to do so, Mr. Allen had an absolute personal right to refuse transfer to the department's custody. Again, because we need to make this explicitly clear to everyone beyond a reasonable doubt, go back to page 3, Indiana Code 35, 33, 11-2. The inmate or receiving authority is entitled to post-transfer hearings or a hearing. Upon request, the inmate may refuse a transfer if the only issue is his personal safety. Let's say that again. The inmate may refuse. In other words, you are obligated to offer them an opportunity to refuse if the only issue is the personal safety, which is what his attorney, his representation would have done for him. All right. Now we're going to move ahead. Sorry, guys. Yeah, this is not bad. See, every time you think that this cannot get worse, Delphi cannot possibly get worse, it gets worse. And trust me, this is beyond, the reasons will always be that it's incompetence. Look, trust me, this is so far beyond incompetence, you cannot imagine. Okay? Incompetence would be an excuse for what this is. If this was not intentional, why would Diener have recused himself? See, he knew. He knew. But the thing is, Diener, you did it too late. Yes, you're recused. But the thing is, recusal is not going to reverse your actions. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. This should be particularly disturbing because had he been given the opportunity to do so, Mr. Allen had an absolute right to refuse transfer to the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. In violation of the Due Process Clause of the Fourth Amendment and NAPU v. Illinois and its progeny, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. A conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. At trial, the undisputed evidence was that LG's cellular telephone stopped moving at 2:18 p.m. on February 13, 2017 for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. In closing arguments, Mr. McClelland called it a hard fact that Liberty's phone stopped moving at 2:32 p.m. The state introduced an alleged confession by Mr. Allen by Miss Monica Walla, a psychologist contracted by the Indiana DOC to treat inmates at Westville. In this alleged confession, Dr. Walla stated Mr. Allen said he had abducted Liberty and Abigail on the south side of the High Bridge and forced them down the hill on the south side of Deer Creek. Dr. Walla said Mr. Allen said he was on the south side of Deer Creek and was planning on essaying Liberty and Abigail when he was interrupted by a van. Dr. Walla said Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north, from the Weber property to Ron Logan's property, taking Liberty and Abigail with him. The state also introduced the testimony of Brad Weber, who said that he left work at the Subaru factory in Lafayette, Indiana. Oh, what are the odds? Question for you assholes out there. How many other people involved in these Delphi murders worked at Subaru? Brad said he left work at 2:02 p.m. and arrived home at about 2:30 p.m. From Mr. Weber's testimony, the state argued that Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take Liberty and Abigail across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van about 2:30 was a detail only the killer would know, and Monica Walla. But the problem is, the state also contended that Liberty and Abigail died near in time to 2:32 p.m. when the Apple Health data from Liberty's phone showed that the phone stopped moving. If the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him across Deer Creek, Mr. Weber would have to had arrived near the Weber property at the end of the private drive before 2:32. When, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:44, let's call it 2:45. His arrival at about 2:30 could not have been a detail only the killer would know because it did not happen. Well, you don't say, and it'll be proven. Okay, not only that, we also know that the detail about a van being an aspect in this theory of these murders has been known since day one. It's another thing that all the fucking idiots and assholes want you to forget. The state knew or should have known this and the state either elicited Mr. Weber's testimony about the time he arrived home knowing it to be false, or failed to correct it once it was elicited. And this is where it gets ultra shitty. Ultra shitty. You understand what I'm saying here? Defendant's Exhibit 3A, as attested to by Matt Hoffman in Defendant's Exhibit 3, is a video recording made on February 13, 2017 by a security camera that was in a house, 5998 West County Road 252 North. The video recording was provided to the defense by the state. And therefore has been in the state's possession. The security camera faced west-northwest and appears to have recorded continuously. Based on the date and timestamps on the video, it appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video and the associated timestamps. The security camera had a wide-angle lens that captured video of traffic on West 252 North and County Road West, North 625 West, and the beginning of the private drive to the Weber property, which begins as a continuation of North 625 West, approximately 190 feet north of the road's intersection at West 25 North. County roads North 625 West and West 252 North are the only roads by which a vehicle can enter the property. Like is that all obvious to you? This is the entrance to the private drive. According to the time and date stamps on the security camera recording, Exhibit 3A shows the white vehicle that is going by, entering the frame at approximately 2:44:33 on February 13th. It shows a white vehicle continuing into the private drive to the Weber property at approximately 2:45 p.m. All right, and we'll show that now. All right. Did you see it? No? Well, here, guess what? I got to zoom. Exhibit 3B here is a video file that contains 3 zoomed clips from the video that I just showed you. Each successive clip is zoomed to a greater magnification. In all three zoom clips, a white cargo van going north on 625 north 625 west just after 244 and before 245. Okay, so basically 244, 245. You're going to see it, and I'll remove my face so that you can see it more clearly. There, I stopped it there so that you can clearly see. It's going to continue. It's in the middle of the screen. One more time. Brad Weber's van. I'm sorry. Let me try again. I shut it down too soon. All right. There you go. All right. Exhibit 3C, which I will show you now. Is this 3C? Jeez. No, this isn't 3C. Hold on. Just a moment. You guys are funny. Don't get your glasses. It's not worth it. All right, here we go. All right. Same thing we just saw. It's just screenshots, okay? But you see, that's what we're talking about. Now it says, back to it. Exhibit 3D here is a photograph of Brad Weber's white cargo van provided to the state. Okay, so let's get that. And it's funny because I've noticed that not many people had knowledge of this specific van. Okay, so there you go. Now, other video files produced by the security camera in the state's possession provided to the defense and discovery and covering the time from 2 p.m. to 4 p.m. do not show any other van. Now listen, there's no other van driving north on North 625 West into the private drive or traveling east on West 25 North into the private drive. So these documents represent that Mr. Weber returned home in his cargo white van after 2:44 p.m. 12 minutes after the time that Liberty's phone allegedly stops moving at 2:32 p.m. Either the white cargo van is Mr. Weber's with him arriving home after 2:44 p.m. or it's not. In either event, there's no other white cargo van or any other van, period, that entered the property other than that one. Okay, you get it? Now, did I skip ahead too far? Sorry. Now, all right, so we're going to look now at 3E. Now, this says Defendant's Exhibit 3E is a redacted FBI subject information sheet for Brad Weber. Dated March 3rd, 2017. The unredacted version of this was provided to the defense by the state and therefore has been in the state's possession. On this document, it says, on 2/13/2017, Weber's phone pings to parent's address overlooking crime scene initially at 2:50 p.m. Hold on, because there's retards in the room. All right. For you in the back, you retards, Nick McClellan, Troll Farm. Brad's vehicle is shown at 2:45 entering his property. FBI says his phone pings at what time? 2:50 p.m. Does that say 2:30? Once again, sorry for the retards. Sorry. Does that say, that's the FBI? Does that say 2:30 or does that say 2:50? Which coincidentally matches up with this video right here. Okay. Say 2:44, 2:44, 2:44, 2:50. 2:50. All right. Let me continue to read, though. It says, Mr. Weber's phone first pings at his parents' address at 2:50 p.m. is consistent with the video evidence showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:54 p.m. that day. Oh, sorry, wrong one. All right. From both exhibits, the security camera recording and the FBI subject information sheet, the state knew that Mr. Weber's testimony about the time of his arrival would be false before it was elicited, or failed to correct it once it had been elicited. When the state introduces testimony it knows will be false, or fails to correct testimony it knows or should know to be false once elicited, a conviction must be vacated or reversed if that false evidence may have had an effect on the outcome of the trial. Those of you in the back, do you realize how significant this little piece is there? You see, I hate to tell you this. I actually love to tell you this because I love to rub it in when I know I'm right. We've known this, okay? We knew that Brad perjured himself on the stand. And guess what? He wasn't the only one. How many states' witnesses perjured themselves on the stand? And how many did the state know were perjuring themselves on the stand and allowed it? Because see, I've held my tongue long enough on this. I was waiting for this to drop before I talked about it. And now it's dropped, so now I'm going to fucking rub it in. Mr. Allen had counsel. Diener and Lesenby did not have standing to decide his safekeeping, especially without him having representation or himself being there. Weber arrived after 2:44 p.m. Who else perjured themselves in this? Who else lied on the stand? Question here. Question. For how many years was the story told that Anna Williams went and picked up those girls the day before, drove them around, and brought them where they needed to be? And then suddenly, after 7 years of that story, Derek German sits on the stand and says he picked those girls up, brought them where they needed to be, and dropped them off. So question, who was lying? The mother or the father? To receive a new trial, the defendant must show 1, there was false testimony, 2, that the government knew or should have known it was false, and 3, that there is a likelihood that the false testimony affected the judgment of the jury. To obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Walla's rendition of Mr. Allen's statement that he became scared after he saw a van. So he took the girls to the north side of Deer Creek and killed them. This was the only statement allegedly made by Mr. Allen that contained any details of the murders that might be true. Question here. What kind of fucking sense does it make to be about to SA two little girls, be scared by a van, and then take the time to race them across a rushing body of water, up a very steep bank on the other side, take the time to derobe them, re-robe the other, kill two very capable young girls with a box cutter, flee, be seen by Sarah Carbaugh, enter your vehicle, not leave a single drop of blood, nothing else, go home, have those same clothes, but not have a single piece of DNA or blood or anything on them. Not move to fucking Haiti or South Africa or Philippines? Okay, so where are we? To obtain Mr. Allen's convictions, the state explicitly relied on Weber's testimony. Okay. About the time he arrived, and used it to corroborate Dr. Walla's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of the creek, killed them. This was the only statement allegedly made by Mr. Allen that contained any detail of the murders that might be true. So, what's more likely? That Walla, a true crime fangirl in and of herself, who was very well aware, likely, of a van, because remember, you just hit the Google and all kind of information comes up about a van involving the Delphi murders. I mean, you can go do it now. Try it. What are the odds that this true crime fangirl said, hey, so, were you scared by a van? Is that what happened when you were killing them? When you were about to kill them, did you see a van? Were you scared by a van? Is that what happened? Yeah, I guess. See, we knew during trial when that all surfaced, we immediately knew the state was using Weber and his van to attempt to drive the nail in the coffin for Richard Allen. And guess what? With this ridiculous ass jury, it worked. The state, therefore, cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have an effect on the outcome of the trial. Alternatively, were the court to find that the state did not know or should not necessarily have known about the security camera video and the FBI subject information sheet for Mr. Bradley Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's convictions or set this fucking motion for a hearing. All right. Now, just give me a moment and we'll move on. Okay, I just want to say thank you to everyone who's leaving comments and joining the live chat, leaving comments. Thank you. And everyone who's hit the like, and also everyone who's sent a super chat or a cash app or any sort of support. Thank you for supporting the channel and participating. Okay. Now we're going to enter, as if this isn't bad enough already. Like, I've never seen anything as bad as this entire thing has been. And hey, we haven't even mentioned any of the witnesses yet. I mean, I'm talking about Cheyenne, both Shelby's, Daniel Pearson. Yeah, we're not even talking about that angle yet. But we're going to enter now. We're going to take this other turn, okay? Because this right here. Now, I know the idiots won't be able to conceive of separating elements of a story here or whatever, but understand that what we're about to embark upon. There's a different point than the average idiot will understand at first presentation, okay? Because I'll tell you now, I have not been ever a believer that Ron Logan killed those girls. Period. Do I think he had knowledge of what transpired and that he harbored criminals? Yes. Do I think he killed those girls? Absolutely not. Then it's a fucking joke. My opinion. Okay. Don't be upset. If you have feelings, if you feel some type of way about it, just go cope. Okay. But this is going to be a tightrope to walk here because this is a minefield. But let's take a look because there are important points here. What this says is Ron Logan's confession to Reese Davis before May 15th, 2017. Okay. Is newly discovered evidence. Dr. Kaur was a forensic pathologist who conducted the autopsies of Liberty and Abigail. His original opinion, held for years, about how Liberty and Abigail died was that two weapons were used. One serrated blade and the other a straight edge blade. For the first time at trial, having had a eureka moment at his tool bench, hey, and look, this is after lengthy conversations with Nick McClelland. Okay, don't forget that gem. For the first time at trial, after having had a eureka moment, Dr. Kaur opined that the girls could have been killed by a single box cutter rather than two different knives. Oh yeah, that's the BS. I told you we're throwing the BS tonight, and that's some real deep BS. But notice how this always happens after meetings with McClelland. Like, what are the odds here? You're meeting with Holman, some BS transpires. Meeting with McClelland, BS transpires. You seeing a pattern here? Defendants Exhibit 4A, as attested to by Matt Hoffman in Defendant's Exhibit 4 is a redacted copy of a tip from the Orion database of tips dated May 15th, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Reese Davis sometimes before May 15th, 2017, while they were in prison together, that he killed Liberty and Abigail. The material was part of Ron Logan's confession to Reese Davis, as it appears in Exhibit 4A. It's produced below. Logan confessed to Reese step by step of killing the two girls. Logan told Reese how he burned his clothes in a fire pit and where it was located, used box cutters, and struggled with one of the girls as Liberty, and thought drops of blood from his nose ended up on her clothes. Reese advised that he killed the older girl first as Liberty. Mr. Allen said that he shot the girls in the back and buried them in a shallow grave. I don't mean to laugh. I'm not laughing about the girls. I'm laughing about how you like how when these confessions come up, the trolls will never, ever, ever say Mr. Allen confessed he shot the girls in the back and buried them in a shallow grave. I mean, never. They'll say, oh, no, he confessed 60 plus times. They'll never say he shot him in the back. He said he shot him in the back, buried him in a shallow grave. They'll never say that because that immediately makes them sound like idiots. Because they want you to believe 65 confessions, which, if you go watch my episode entitled The Confessions or whatever it is, okay, some months ago, I go into detail analyzing Harshman's statements regarding those confessions. And you should realize that those confessions, there's not 65 confessions. There are 60 plus instances in which Allen said something which Harshman then took it upon himself to interpret as confession-like or implicating guilt. You see the difference? Well, apparently Harshman is an expert on language and the use of language to implicate guilt, just like he happens to also be an expert on voice analysis, being able to attest that that's absolutely Richard Allen's voice on the Bridge Guy recording because he's listened to a lot of phone calls. You see how all of this evidence that was allowed to be introduced into trial is baseless? Yes. Mm-hmm. And some is outright false, as you've just learned. But let's continue. Ron Logan's confession to Reese Davis, as reflected in the tip in the Orion database and made a mere 3 months after the girls were killed, was detailed. Law enforcement followed up on the tip. Defendant's Exhibit 4B, as attested to by Matt Hoffman in Exhibit 4, accurately reproduces the handwritten notes taken by ISP First Sergeant P. Hansard about the interview with Reese Davis on June 21st, 2017, at the Newcastle Correctional Facility regarding Ron Logan's confession to Reese Davis. Those handwritten notes of First Sergeant Hansard are attached to the ISP Detective Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of his interview with Reese Davis about Ron Logan's confession provide even more detail. Now let's take a little break because now we need to go into Mr. Hoffman here. Okay. Okay, just give me a moment, please. Now let's take a look here. Oh my goodness. There's just so much to get through. Let's see. This is well, maybe I should show you this. Okay, this is what we've already done because we'll do some Hoffman. All right, look. Investigator who helped the lawyers working for Richard Allen. Included in discovery is a video filed. A video file. This is on Brad Weber's van. Okay, video recording. Just showing you here the house circled. Okay, you see that house circled at your lower right. Video recording was made February 13, collected by LE, blah, 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 blah. Security camera faced west northwest, recorded continuously, blah, blah, blah. Okay, blah, 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 blah. So you've seen that. Okay. Now let's get this one up. And just imagine, I had these all prepared. Imagine if I did not have them together. All right, let's see. Now we're going to look at Hoffman. There we go. Included in the discovery provided by the state to the defense was a tip regarding Ron Logan's confession. The tip was designated in the Orion tip file dated December 4th, but it's a tip from sometime before May 15th. Exhibit 4A is a redacted version of the tip about Ron Logan's confession. I have reviewed the original tip and compared it with the redacted tip that's in 4A. Exhibit 4A is a true copy of the original tip with the only personal information of the person, with only the personal of the information of the person who provided the tip and sensitive details about the coverage of the lead redacted. Okay. All right, so here we go. All right, this says narrative. Redacted contacted the FBI public access line unit to report a tip in the Delphi homicide. Redacted provided the following. Redacted, Reese Davis, DOC number 114393, is currently incarcerated at Newcastle. All right. Redacted received a phone call from Davis advising he is in the same block as Ron Logan, owner of the land where the Delphi homicide took place. Redacted reported Logan is in prison for parole violation. Logan confessed to Reese step-by-step killing of 2 girls. Logan told Reese how he burned his clothes in a fire pit and where it was located. Used box cutters. Now we're getting to the root of the matter. Box cutters. And struggled with one of the girls and thought drops of blood from his nose ended up on her clothes. Reese also advised that he killed the older girl first. Redacted said Reese wants nothing from this but justice for the girls. Watch this. You guys want to see how fucked up this is about to get? Look, let me take a poll. Okay, let me stop everyone in the chat. Everyone in the chat, please put a 1. Please put a 1 if you want to see how messed up this is about to get. Yeah, this is about to get messed up. All right, here we go. Let's go. Let's go. Kathy Shank. Investigator Kathy Shank. Wow, that's rich. ISP investigator Kathy Shank. Wow. Check it out. Lead coverage. Fully cleared. Fully cleared. Look, I know I like to exaggerate, but really, you guys gotta. This one here is rich. I mean, look at it. Fully cleared. Fully covered. Covered by Kathy Shank on 1/6/23. Discontinued. Lead is discontinued due to no follow-up with Reese Davis. Ron Logan passed away January 2022. Investigate, locate, interview Reese Davis. Investigator Jay Harper. Fully covered. Covered by Kathy Shank on behalf of Jay Harper, 5/9/23. Wait. Do you mean that because Ron Logan died, they stopped down this road? They stopped going down this road? Now, I've already told you, you very well should understand that it is not my theory that Ron Logan had anything whatsoever to do with this at all. That's not my bag here. All right. But do you think it's appropriate that that lead should have been cleared or covered because he died? Or do you actually still maybe go solve the crime? All right. So let's continue. Investigator Shank. Sorry. Now, where was I? I was looking at Hoffman's. Maybe we got to get back to Hoffman's, right? Is that this one? Yeah. Okay. Now back to Hoffman. That's not it. What the hell? Where is it? Oh gosh. Okay. Which one was it? It was 4A. No. Maybe it's this one. All right. Check this one. So hard as they are to decipher, blah 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 blah. Okay, so this is where I take issue with this whole deal. But let's listen. At this moment, we're going to pretend that we're listening to Nick McClellan. We're going to suspend our disbelief, okay? We're going to suspend our disbelief totally. Just suspend the disbelief. Let's go on a fairy tale. Let's go on a fantasy. Let's go on a world of make-believe. Let's just consider, okay? Just consider this. We're just going to open our minds and consider this for a moment. Remember, these are the notes. Walking, talking, knowing one of their dads. Okay, I see. One of them wanted to turn around, grabbed the youngest, that's Abby's, shoulder. It's okay. The oldest freaked out, that's Libby. He said one of the girls said something about calling police. Sexual attack wasn't true. Originally not trying to go rape them. Paranoid about probation. Felt like he crossed the line when he grabbed the youngest one. Suspend your disbelief. I know it's hard. He started talking. Ironic. Should have been in school. Knew one of their moms who waitressed at a bar. Animals walked with them, willing to go check out horses. He told them he had rabbits in the barn. Walked through the trail in the woods. Oldest was paranoid. Didn't want to go. Youngest wanted to see horses. Oldest turned to help youngest. Oldest started kicking. Youngest, he now grabs oldest. He said he got hit on the nose, scared he got blood on one of the girls, pulled a box cutter out, slit oldest one, hit an artery. Youngest scared, took the little girl, Abby, with him for a while, never said where. He said he cut her too, cut both necks. He left again, came back later in the evening. There was a search going on. Later on, late hours, he tried to move the oldest one to an area not going to be found. Place where four-wheelers are kept. Burned his clothes in the burn pile. Hiking boots, gloves, bag. Soles of boots in burn pile. Next morning, two other girls knocked on door, asked to search property. Felt weird if he would say no. He let them take off. Got a hold of a family member, got out of the area. First time he seen them from property. Whatever, he may have guns, whatever. During a struggle, youngest girl scared, not maybe, I don't know, happened to friend to stand there. Head, neck, artery. Defendant's Exhibit 4C is a handwritten note, blah, 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 blah. We're going to skip all that. It says, Reese's handwritten note about Ron Logan's confession says, Mr. Logan has made references to killings in Delphi. He told me he was the one who killed those girls, that it got out of hand. He walked with them in the woods to his property, and the girls wanted to turn back. Said something about walking. He grabbed the youngest girl to reassure her it was okay. However, they panicked, and he also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it was took too far. So in addition to the other known facts, Ron Logan confessed to Reese Davis that he used box cutter to kill the girls. If instead of, for the first time at Mr. Allen's trial, Dr. Kors said 7 years earlier, the girls could have been killed by a box cutter, there certainly would have been probable cause to arrest and charge Ron Logan with the girls' murders. As it was, FBI, blah, 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 blah. Under the circumstances, Dr. Kors' testimony about a box cutter possibly being used to murder the girls makes Ron Logan's confession to Reese Davis newly discovered evidence, blah, 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 blah. Now, this is where everyone will hate me, and that's fine. That's fine. I don't care. I think it's total bullshit. First of all, if Richard Allen's freaked out jailhouse confessions are no good, then why are Reese Davis's freaked out jailhouse confessions or Ron Logan's freaked out jailhouse confessions? Why is any of that credible? So suddenly Ron Logan is credible in confessing to this. So there's some things that, see, if you read that, there's some things that don't make sense. How do you explain the bridge guy? How do you walk them off the south end of the bridge, I guess is what I'm getting at, to Ron Logan's backyard? And why do they become nude if that's the story? It doesn't add up. It doesn't. The way that would add up is if Ron Logan met them at the split and walked on down to his property, like I told you many times, uh, that would have happened. Okay, so in other words, I've said many times that any searchers would have found those girls immediately, because the only other trail, which is the one they seem to be referencing here, that what I just read, they seem to be referencing the trail, right? Well, the trail goes right down to Ron's backyard after you're going through the ravine. But in that case, how do you explain bridge guy video, south side of the bridge, blah 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 blah? It still doesn't add up. Okay, so my point in all of this is all bullshit. But you know what? You know what does smell right? You know it does smell right? The knowledge of a box cutter. Just like Dr. Monica Walla had knowledge of a van that she fed to Gray Hughes, right? And that was used in this trial, and he knew about it way before. So who were they talking to? Did she also have knowledge of a box cutter because of this? Because this shit that I just read to you, don't think this is the first time it's been out. We've known about Reese's statements about Ron for a very long time, right? Remember all the stories about Ron Logan's cellmate? That's what we're talking about. So, did Monica Walla, in the midst of her extreme obsession with Delphi, did she become aware of this statement that Reese gave, wherein Ron Logan, he alleges Ron Logan said he used a box cutter? Did she feed that to Richard as well? I mean, I've said so many times, and from the very beginning, why would Ron Logan leave two dead girls on his property? It'd be the stupidest thing you could ever do. Why would the FBI not arrest Ron Logan? Come on, man. I mean, just think about it. They put Ron in jail for how many years for that driving offense? For the same reason. Now think. Think about this. When they thought Ron Logan was the killer, they put him in jail as if he's a killer. When they decided that no, he's dead, now Richard Allen's is the killer, what did they do to Richard Allen before his conviction? They put Richard Allen in prison and treated him like a killer. Are you seeing a pattern here? What goes on in this Carroll County? There's a lot I like to talk about Ron Logan's investigation, because particularly what's impressive to me is Nicole Robertson saying they arrived at approximately 1 p.m. Come on now. Remember what? Here's a question. What time did those girls truly arrive at that area? Do you think Nicole Robertson would have said approximately 1 p.m. if it was approximately 2 p.m.? Because isn't 1:49 or whatever it is, isn't that a lot closer to 2 p.m. than it is to 1 p.m.? So you would say approximately 2 p.m. right before 4. I mean, right before 2. You wouldn't say approximately 1 p.m. So that's my piece. Okay. So what I am saying is, my take on this is that what we're actually talking about with this section is not so much Ron Logan. Okay. Of course, the attorneys, look, I've told you before, I play no favorites here. Okay. McClellan, I don't favor McClellan. I don't favor Baldwin and Rossi. You understand that? I'm not over here to butter anybody's bread. All right. I'm here to give you my critical analysis or my criticism of this entire thing for justice for Libby and Abbott. That's all I do. I'm not here to free Richard Allen. I'm not here to convict Richard Allen. I'm not here to kiss the ass of the attorneys on one side or the other. What I'm here to say, what do I think about the actual value in all of this, the truth in all of it, the legitimacy of all of this? And so for me, the fact that Ron Logan may or may not have confessed makes no fucking look, doesn't matter to me, makes no difference to me. Now, what I extract of value from this is the fact that box cutters were mentioned. And when was this supposedly? Think about it. This is May of 2017. Hold on, let's back it up, baby. Back that ass up. Let's look at the date again. May 15th, 2017 is the day that this is entered. So that means it occurs prior to May of 2017, which means the box cutter as an element in this mythos, okay, was known at least at its latest May 15th, 2017. Box cutter was an element in this mythos of this crime. So, if a box cutter was mentioned as early as May 15th of 2017, how is it something only the killer would know? It's just as bad, or almost, it's nearly as bad as the white van, which was known February 14th, 2017. All right, so let's move on. Now, this is going to get extremely beautiful at this point. Okay, this is where it gets really good. So let's get back to it. Let's see. All right, beautiful. Thanks everyone for being here. If you sent a super chat, I just want to say thank you. I see that some have come through. I'll talk about those at the end. But thank you so much for supporting the channel. If you're supporting the channel, hitting the like and joining the chat. Thank you so much. I apologize. I'm not reading the chat at the moment. I'm trying to stay focused here, but I'll get to the chat when I'm done with this. Let's see. Number 3 here. Very, very good shit is coming. Okay, very good shit. Defendants Exhibit 5, the affidavit of Stacy Eldridge, states that dirt or water damage to the phone could not have caused the auxiliary jack on Liberty's phone to log wired headphone plugged in and wired headphones unplugged. Oh, this is getting real. This shit is getting real. Miss Eldridge's expert opinion is newly discovered evidence that would probably produce a different result at a new trial. Well, no, yeah, no, I'll refrain from commenting on that one. Okay, at trial, Mr. Allen introduced evidence through the testimony of Stacy Eldridge, a digital and mobile forensics expert, that someone plugged wired headphones into the auxiliary jack of Liberty's phone at 5:44 p.m. on February 13th, 2017. And remember, I've said to you before, that's only minutes before the last phone leaves the geofencing area. Oh, yeah. What are the odds? And unplugged it at 10:32 p.m. the same day. To counter this, the state offered results of the seat of the fucking pants Google search by First Sergeant Cecil, the state's quote unquote phone expert. According to First Sergeant Cecil, The Google hearsay told him. Oh, deserves a round of applause. That does deserve a round of applause. Whoever wrote this paragraph, look, I may or may not. I just want to say that particular phrase deserves a round of applause. So kudos to whoever wrote that paragraph there. That Google hearsay told him, in his expert opinion. Oh, what a sentence. The Google hearsay told him, in his expert opinion, the log on Liberty's cell phone showing wired headphones were plugged into the auxiliary jack at 5:44 on February 13 and unplugged at 10:32 p.m. could have been caused by dirt or water damage to Liberty's cell phone. And hey, that's funny because that's also what the trolls say. So, hey, guess what? The troll fucking farm says it's dirt or water damage. It's dirt or water damage. Oh, but they're going to be fucked because they don't realize this. The defense had no opportunity to counter First Sergeant Cecil's expert opinion, courtesy of Google. The court should have read Mrs. Eldridge or Miss Eldridge's affidavit, Exhibit 5 in its entirety, but the short version of Miss Eldridge's actual expert opinion is nothing in the data on Liberty's phone indicated there had been water damage. None of the reports or extractions related to Liberty's phone created by law enforcement officers reflect dirt or water damage. Photographs of Liberty's phone taken by ISP did not show the phone to be wet, dirty, or covered with debris. Can't make this shit up. Mrs. Eldridge or Miss Eldridge is unaware of any scientific or technological research suggesting that water or dirt damage to any iPhone S or 6S would cause the phone to inaccurately log wired headphones in, wired headphones out. According to Apple Health data, the phone stopped moving at 2:32. At trial, the state contended Liberty and Abigail died close to that time. Complete speculation on the state's part, by the way. And that Abby Williams had hid the phone under her body heroically. Ooh, how disgusting. How disgusting to fetishize those young girls as heroes. Miraculous superheroes. Okay. The state also provided testimony from former Delphi Police Chief Steve Mullen. Oh, he's credible. And Indiana State Police Lieutenant Jerry Holman. Oh, he's credible. That there was no evidence that Richard Allen returned to the location where the bodies were found after allegedly being spotted by Sarah Carba on 300 North at approximately 3:50. Well, you know, because obviously, how can you return to somewhere you've never been? That's look. For him to return to the crime scene would have meant that he was at the crime scene. So obviously, he didn't return to the crime scene if he was never at the crime scene. But some people were there, weren't they? If Miss Eldridge's actual expert opinion that wired headphones were plugged into Liberty's aux port at 5:44 p.m., remember, just 3 or 4 minutes before the last phone leaves the geofence, and is unplugged almost 5 hours later, were credited by a jury, the state's narrative is impossible. And this is where the defense, let me take another aside, and this is where the defense really fucked up. They dropped the ball during trial on this particular aspect. And it's really unfortunate. I think that they were distracted. I don't know. Let's continue. Someone other than Richard Allen was handling Liberty's phone multiple times, long after the state contends that he left the crime scene before 4. Miss Eldridge's opinion that dirt or water could not have caused Liberty's phone to log wired headphones being plugged into and unplugged from the phone exculpates Mr. Allen and would probably produce a different result. Accordingly, the court should either vacate Mr. Allen's convictions or set the motion for a hearing. Okay. Now, here's a problem, though. That should, I mean, let's continue before we. Let's continue. I don't want to be too mean to the defense. This probably should have been dealt with during trial, though. I'm trying to be nice here. All right, so here are some key bullet points for your notebook. If you're a note taker, she says, received my bachelor's in management information systems, received my master's in computer information systems. I provide digital forensics and mobile forensics through my business, Silicon Prairie Cyber Services LLC. LLC. What am I? My eyes are starting to cross on me from not reading too much. I'm an adjunct professor at Oklahoma State University Institute of Technology, where I develop and teach digital forensics and mobile forensics courses. I also teach cybersecurity courses. Yeah, I'm getting tired of reading. You see, I'm slipping up every other word. I'm also an adjunct professor at Bellevue, where I teach cybersecurity and digital forensics courses. I was director of cybersecurity at Lincoln Electric System from 2017 through 19. I was a senior staff cyber investigator and program manager at General Electric from 2012 to 2017. Now, I worked for the FBI from 2003 through 2012 as a digital evidence instructor at a computer analysis response team senior forensic examiner. Okay, so listen, let's do this. Let's very quickly get her CV together in our minds. Graduated 2001, received a master's 2008, right? During that time, she worked at the FBI as a digital evidence instructor, computer analysis response team, senior forensic examiner. Not too bad. Immediately thereafter, she worked at GE as a staff cyber investigator program manager for 5 years. Afterwards, she worked cybersecurity as director at Lincoln Electric System for 2 years. She's a professor adjunct at several universities, provides digital forensics through her own contracting services. Okay. She has the following certifications, and I'm not going to read them, as you can see. Several certified FBI certifications. Okay. Previously served as an expert witness in some cases. Now, here's where the meat comes. Is that if that's already not meaty enough to prove that, listen, no disrespect, sir, but this is no Christopher Cecil, who did not really even know what iPhones were before this case. You understand what I mean? This is no Christopher Cecil. This is no cop. This is no county, or this ain't a local who's got no pedigree and who barely knows about iPhones. Okay. She says, data from Liberty's phone showed that wired headphones were plugged in to the phone and out of the phone. Wired headphones were plugged in at 5:44 p.m., unplugged at 10:32 p.m. And there's no disputing it. An Apple iPhone 6S is equipped with sensors to indicate water damage. Just like take a little aside here. Any of you who ever owned that phone, I did own that phone, guarantee you, There are sensors that are visual indicators of water damage. Often, with all of those phones and prior, you bring those phones in to the Apple store to have some service. The very first thing they do is they get the damn phone and they shine a light, right? You get where I'm coming from? There's a physical indicator of water damage. There was no indication in the data from Miss German's iPhone that indicated the sensor identified water damage. I would expect to find evidence of the water damage notification that it displayed to the user to be present. I reviewed the following extractions and report produced by the state in this matter. 4 data points. The Celebrite extraction from February 15, 2017. Another Celebrite extraction from October 12, 2017. A digital forensics report by Cecil, August 2019. And a digital forensics report by Cecil, August 2024. None of the above reports or extractions contain evidence of dirt or water damage to Liberty's iPhone, nor do they indicate that it was particularly dirty or covered in debris. I reviewed photos of Liberty German's iPhone taken by the ISP. The phone does not appear to be wet, dirty, or covered in debris in any of the pictures. No pictures were taken of the phone displaying a message indicating that liquid had been detected. No pictures were taken of the control center of the iPhone 6S to document that headphones were being reported as being plugged in when they were not. I reviewed the chain of custody for Liberty's iPhone, and it did not document that it was received in a wet or dirty or damaged condition upon receipt. iPhones that have recent water damage are known to reboot spontaneously, requiring multiple attempts to complete the extraction with a forensic tool. No instances of this were documented or reported by the ISP. I'm currently unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6S would cause the phone to inaccurately log wired headphones in or wired headphones out. Well, you know what McClellan's going to say, though. They say, "Oh, yeah, well, obviously Google says that if a water drop gets in there, it's gonna register as it's gonna indicate headphones plugged in, and it's gonna dry out, and it's gonna indicate that headphones are unplugged, and I mean, according to blah, 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 when we know Richard didn't return to the crime scene, and then yeah, BS, 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 BS." Okay, now that covered that particular thing there. Now here we go. We got some more richness here. Now, this is rich for an entirely different reason, and I'm glad that you guys who are here, you may remember. Okay, let me put it this way: you may remember that these very good attorneys, Baldwin and Rozzi, respectfully, and I don't want to forget Auger, respectfully requested that the judge preserve all evidence. Now, doesn't that seem clear enough? Doesn't that seem specific enough? Hey, this shit's probably going to appeal, so please preserve all evidence. Treat this shit sacred. Does that not seem clear enough? Right, but this judge, this gem of a judge, She said, "Nah, no, I'm not. I'm not going to preserve all evidence. Why would I do that? It's not specific enough. You should delineate what you need." So this is our attorney's attempt to delineate the most important five. It's actually four, but let's just get into it. Let's look at it really quickly. So she says, or so they say, and this is actually Baldwin, but I look at this as a group effort, you know. So number one, all physical evidence taken from the crime scene or near the crime scene, including any belts, cigarette butts, or any electronic items, whether they were working or not. What? Oh my God. Oh my God. Do you understand what that statement tells us? No, because we're retarded, Prof. Yeah, me too. Dude, belts, cigarette butts, electronic items, whether working or not. Well, you know what it tells my stupid mind that's somewhat logical at times? Is there a belt involved in this? What the fuck? Is there a belt involved in this? Is that how the girls were restrained? Were they bound with a belt? Was this some belt? What? How was a belt used? More cigarette butts. Hmm. Hmm. Can we say DNA? Can we say DNA? I know some other shit about some cigarette butts, but I'm gonna save that for later. And third point, that's even more mind blowing. Any electronic items, whether or not they were working. Hold on. Is there another device? Is this Abby's phone? Or is this the phone that the Snapchat that we know did not come from Liberty's phone come from? So hold on. So you got another device that's not working, which means they couldn't extract it, right? Isn't that kind of what it means? It's not easy to extract. So do we have another device that was not in working condition that was found? And is that maybe where the fake Snapchat comes from? Something's wrong here. Because you know the way I take this shit. I always expect the worst out of people. Absolutely. I am always going to expect the absolute fucking worst out of people. You know what this tells me right here? This tells me right here. This tells me, I read it like this. There is a belt, there are cigarette butts, and there's a device that's not in working condition. And they're afraid that the state's going to destroy that evidence. Now, notice, none of those were used in trial. Okay? So understand what's going on here. They're not used in trial, which means they're not evidence brought into the trial, but they're probably in discovery. So is this what the message is here? So in discovery, we got a belt or belts. We got cigarette butts, and possibly we got at least one device or two that may or may not be functional. It would be awfully difficult to do an easy Celebrite extraction from a non-functioning phone. Tell you what, it's getting hot in here. And that's just number one. So what else do we have here? Number two. I think I just lost my files. Where are they? Number two. All DNA swabs. Here's another key point. Like when I'm telling you every word matters, taking all DNA swabs taken during the investigation, or even during trial, or afterwards. Okay, so that's pretty fucking clear. All DNA evidence before, during, and after trial. And you know what that should also mean? All the way to day one. All forensic evidence obtained during investigation, even during the trial or afterwards. What's going on here? Any and all reports or lists that identify anyone whose interviews were erased while in possession of law enforcement or the state of Indiana. Now, that's a big one. That's a big one. You know why that's a big one to me? Did they lie about not being able to account for whose information was deleted? I mean, I have a question. Didn't you interrogate Daniel Pearson? Was that one of the ones that was magically deleted? Ooh. Shouldn't you be able to account? I mean, I remember a little glitch in one of these PR campaign stops in this PR tour that the state is doing right now. I remember a statement to the effect of, yeah, we deleted 70 days worth of shit, but it's okay. We accounted for who all that was, and we went back and we re-interviewed them, blah, 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 blah. Oh, really? Because I thought the story was you could not identify those, and so you could not. So which is it? Can you identify who you deleted, or can you not? Sounds like the defense wants the list. Since you say you were able to go backtrack and re-follow up with those people, right? Sounds like some lies being told. I mean, so are we saying that not only the witnesses were allowed to lie and perjure, but has the state actors been lying too? Ooh, do we have a RICO on our hands yet? And speaking of Daniel Pearson and all the other fucking lying ass witnesses, potentially. Number 5, all evidence identified in the state of Indiana's exhibit list that may be exculpatory. Oh, well, how would the judge determine that? How would the judge who has shown or exhibited clear bias, how would she be trusted to identify what may or may not be exculpatory in nature? The items identified in these points are not intended as an exhaustive list of items that the defense is requesting this court in order preserved, but rather are a few of the specifics. Because this unhinged court previously denied the defense's request to preserve all evidence as lacking specificity. The state of Indiana has a continuing obligation to preserve any evidence that may be exculpatory in nature. And that's just the matter of fact. Okay. Now, let's see, how much further do I want to go? Let's go with this one. Because there's another point I guess we should hit before we end tonight. And it's this one. Defendant Richard M. Allen respectfully requests that this court issue an amended abstract of judgment. In support of this motion, the defendant states the following. On December 23rd, 2024, this court issued an abstract of judgment in this case. Under Part 4 of the form, the court indicated that there were no mental health concerns with the defendant. This is not a joke. This is not a joke. Under Part 4, the court, that means Judge Gull, indicated there were no mental health concerns with the defendant, yet at trial evidence was presented that the defendant had significant mental health concerns throughout this case. Dr. Walla, Dr. Martin, and Dr. Westcott all testified about the defendant's mental health issues. Video evidence revealed behavior by the defendant while awaiting trial that raised concerns about his mental health as well. Providing accurate information on the abstract of judgment is critical to ensure the DOC is aware of defendant's mental health issues so that defendant will receive continuity of care and appropriate placement, effective treatment, and medication. Wherefore, by defendant by counsel respectfully request that this court issue an amended abstract of judgment reflecting the change in answer mental health concern from no to yes. Defendant additionally requests that this court forward a copy of the amended abstract of judgment to the Indiana DOC. Okay, I apologize. I needed another water. Okay, so so that is that. Now, Now, let's just be real here. If Mr. Allen is going to spend another day, much less month or year, in prison, do you not think that he should be considered to have a mental health concern? I mean, it's pretty obvious. There are mental health concerns with that guy. I mean, so let's do a little review. This has been so much, right? This has been so much. Imagine how much ground we've covered in just these 2.5 hours. So remember where we started. We started with Mr. Allen had counsel from the day of his arrest. Judge Diener, McClelland, Lesenby, all ignored due process, violating his constitutional rights, moving him to White, and then moving him to safekeeping at Westville without representation, even though he had representation, and without his own presence. He was not offered the opportunity to reject safekeeping. Remember, it appears as though Lesenby didn't have standing to request safekeeping, and Diener didn't have jurisdiction to decide on it, and Diener had the conflict of having drafted or assisted Lesenby in drafting that request. Okay? Then we move beyond that. We went into Brad Weber. And how you've clearly seen, I mean, maybe we should look at it again just for shits and giggles, so to speak. No, that's not the one I want to show you. I want to show you the damn Zoom one. Come on, prof. Oh, this is the zoomed one. Yeah, I just got to go to this section. Okay. Yeah, there we go. There you go, Mr. Weber. There you go, Mr. Weber. Brad Weber. 4:45. No, not 5. There you go. 2:45. And there you go, Brad Weber from the FBI, right? 2:50, his phone pings. So is it adding up for the idiots all the way in the back? Come on, I'm trying to be nice. You know, I'm not a mean person. Okay. 2:45, 2:44, 2:45. There we go. Okay. Yeah, that's him. That's him. 2:44, 2:45. And then FBI says, yeah, his phone pings at 2:50. Yeah, remember? Yeah. Mm-hmm. Right. I mean, this is coming from discovery, so clearly the state knew it. But the state allowed, you know, because remember, their timeline has to work. You get what I'm saying here? Like, the state had to allow him to lie, to use that van, because the timeline has to work. And if they told the truth about what they knew, that the van passes at 5:44, the phone pings at I'm sorry, keep saying 5. I'm thinking about the cell phone. The 2:44, the van passes 2:44, 2:45, and then 2:50, it's pinging. The state had to allow that to be misrepresented, though, to push that timeline 15 minutes ahead in order to make that van frighten off Richard Allen before that phone stops moving at 2:32. Because the whole theory is that the phone frightens him. The van frightens him. They rush across the creek. Within 2 minutes, somehow magically make it across that rushing creek. That's at a very high stage because of the snow melt. Somehow manages them to kill them in time, or at least Abby, in time for her to die within 2 minutes of spotting Brad Weber. They make it across the creek. He kills Abby without leaving any blood or anything. Then she lays down there and has the wherewithal to fucking hide the phone behind her back so that it stops moving at 2:32. Then he kills the hell out of Libby violently, and there's blood everywhere. And then he has all this time to mess around with sticks. Hangs out there, even though he's startled by the van at 2:30. He waits until 30 minutes later to be seen by Sarah Carbaugh. It just doesn't work out. I mean, and what they don't realize is it will never work out. Okay, none of this will never work out, at least in the public's mind. I mean, you can have the guy in prison, you can torture him, you can kill him, you can do what you're going to do, but this will never work out for the people. And that's where your fatal error is. And then to make matters worse, or to add insult to injury, not only did we have Wallow with the white van, now we seem to have Wallow with the. Do we have Wallow with the box cutter? So we have Wallow with the white van, Wallow with the box cutter. Oh, so tell me, did you have a box cutter from work? Yeah, probably. How big of a role, how crucial is Walla in all of this? Then we move on to Stacey Eldridge and the Google search hearsay expert opinion. And remember our juror, because I'm not going to forget about her. I criticized her highly. All you got to do is go back a couple shows. I did the juror. I called it The Juror Speaks. Okay. 5 days ago, I did a show called The Juror Speaks, in which I criticized the juror's statements. And what was she saying? She said, yeah, we didn't care about the bullet. She said, yeah, we didn't really care about the confessions that much, but you know that's bullshit because that has a subconscious effect. It has a psychological subconscious effect. Should have never been allowed in, but it was. But it had the subconscious effect. So then what do you have? Well, we had the van. We had the bullshit van that we now know is false. Timeline don't work. And we had the fact that only Richard Allen was there to choose from. Yeah, because the state hid how many people from you? Oh, that's a tough one, right? That's a bitter pill. That's a bitter pill. And you wonder why the state did not want those sketches in and why they were not allowed in. Well, what if one of the sketches matches one of the other people who were there that day. Well, then you'd have him to choose from too. Then suddenly, it's not just Richard Allen. It's Richard Allen and someone else. And hey, maybe even a third, because what about the guy all in all black? A very tall, muscular guy in all black. Oh, that's a third. Well, then you got the guy by the mailbox. Well, that's a fourth. But hold up. Suddenly you have all these male figures. And then you have a little classmate girls who kind of look like boys. Suddenly you have all kind of people to choose from. Not just Rick Allen, but you see, the judge made sure that was a limited menu the jury had to choose from, that the only choice they could make was Rick Allen. That's why we call it a railroading. So the trolls are out there running around right now. Oh, they're saying Ron Logan killed the girls. They're saying Ron Logan. They're saying going back to Ron. No. I'm still saying a fucking group of people killed those girls, which Ron Logan knew about. Those girls, we know now because Jerry Holman admitted the Anthony Shots account absolutely did lure those girls out to their deaths that day. Anthony Shots lured them, Kelsey delivered them, and the group killed them. And that's the way that went down. So why did they let Anthony Shots go? Why'd they not arrest Keegan for many years? There's a whole bunch of shit that don't smell right. So should a proper investigation ever be done into this investigation and into these people? I believe the whole group will go down. Since when do you have a murder where all the witnesses lie? I mean, usually, isn't that an indicator? Just a moment. So I know many of you have been waiting for me to talk about the latest PR stop by McClelland. And so I will be doing that. I believe that the next stop here, the next chance we get, we'll be taking a look at McClelland's unbelievable performance at his latest PR effort. Remember, they're not going to stop. I'm telling you now. They're scared shitless. They're pulling out all the stops in an attempt to salvage this and right the course, but it's not going to happen. I mean, these things are it's precipitous lies and mistakes, and it's one after the other. There's a constant. It's totally getting out of control, and it has been for quite a while now. So, guarantee you, though, they're going to continue to try to grab hold of this train, even though it's a runaway. So, expect more. Expect more. Expect all of these folks from the state to continue to come out and try to push their narrative onto people. And I just wonder, when are they going to start to realize that it ain't working? The jig is up. You're not going to convince, like the numbers. Listen, I watch closely. Okay, I have my finger on the pulse here. I like to think that I do. And I just wonder, when are they going to realize that the odds are not in their favor? The numbers are not on their side. A majority is now reluctant to believe what the state of Indiana is telling them about the Delphi murders. And that is a fact. If they weren't concerned about it, why would they be out here doing interviews? Don't they have jobs to do? Don't they have crimes to stop? Criminals to catch? People to put in jail? So why are they making the PR rounds with friendly? They're doing all the friendlies, right? I mean, surely it wouldn't be because they feel the shit is out of control. They're trying to get a hold of it, and the defense came out and said their piece, and it's unbelievably compelling. I've said so many times that most people have the ability to discern the truth from fiction. And once those attorneys came out, and I mean Baldwin, Razi, and Auger, once they came out and started speaking, you know what I saw? I saw all the public saying, wow, it's so obvious they're passionate about the case and telling the truth and being honest. So my question is, when are these things going to be looked at? Remember, there's still the leaks. There's still deaths that have occurred. There's still inappropriate communications that were going on between Judge Gull's office and YouTubers and the Indiana State Police and YouTubers. When is all that going to be investigated? Because it should be. And like I've said, the defense clearly fucked up on a number of occasions, in a number of ways, by calling these guys Odinist rather than career criminals. which they should have, a gang of criminals, by not addressing the Eldridge uh, testimony good enough, or the phone, things like this. Their mistakes have been made. But what we heard tonight was really alarming. It really was. Uh, all these things are compounding. Just think about it. They arrest this guy. Holman says he didn't intend to arrest him. He just wanted to talk. Didn't read him his rights. Talked, pissed him off by manipulating his wife right in front of his face. And then when he got mad, he rage arrested him. Oh, you're going to get mad at me while I'm putting cuffs on you. You're under arrest. Don't read him his rights. Arrest him out of anger. Possibly lied to get the PCA signed by the judge. You colluded to have a safekeeping order drawn up with the judge. You had already moved him. You possibly had no standing or jurisdiction. The judge fucking recuses himself because he knows he just stepped in a whole pile of shit. Then you throw this guy in the exact place you're going to get a plea deal out of him. You put him in Westville, you put him in a pressure cooker. You said, put his ass in Westville. He's going to be in that fucking pressure cooker, and we're going to get him to plea. But it didn't work out, did it? You fucked up. It went to trial anyway. And now you're in the middle. You got caught with your... Let me put it nicely. Pants down. You put him in that pressure cooker to extract or force a plea deal. And what happens instead, because of the pressure, his mind cracks. And when his mind is broken open, you send in Monica Walla with inside information. Then you take these witnesses. None of them wanted to cooperate with you. You forced them all to. They get into court. They want to please you. They know that that's not the guy they saw. But they do what they have to do to make you happy and to get justice for Abby and Libby, even though they know it's in their hearts, it's not the right thing to do. Prosecutor allows it all to go down, even though he knows it's not the right thing to do. The family members allow this shit to go down, even though they know it's not the right thing to do. Everyone's on board with it, although they all know it's not the right thing to do. While the actual guilty parties hide in the shadows. They hide in the shadows, keep silent. They don't want to give themselves away. But maybe they don't realize they've already told on themselves in the first years Well, what is open source intelligence? Can the military and the federal government use open source intelligence to solve crimes and combat corruption? I mean, shit, there's no search warrants needed for that, right? Anyway, God bless you all. Uh, let me thank our supporters, first of all. Huge thank you goes out to Chevy Killer 306, Mark Ellis. Huge thank you goes out to Mark Ellis. I'm just checking my devices here. Huge thank you. Okay. Another thank you goes out to Imagine for becoming a member and Lisa for becoming a member. We hope you enjoyed those memberships. Another thank you. Huge thank you to Keith Kellogg and to that girl. Another thank you to Kevin. Thank you very much, Kevin. Everyone who supported the channel with a donation, a contribution, thank you for that. Everyone in the chat, thank you so much for being here. Huge thank you to everyone in the chat. Everyone just watching, leaving a like, whatever you do, thank you. And if you're on the replay, please also know that you can leave comments down below in the comment section. I always say it because I mean it. I do love the comment section down below. I truly love it because as the weeks go by, the comments come in and I'm always surprised by what I get. I also have an email. It's on the About Me section of the YouTube page if you're on a computer, if you need to email me or would like to. I just thank you all so much for being here. I mean, this is heartbreaking. You just have to know. But for me, it's a heartbreaking endeavor, our trial, our case, or whatever. And truly, it's to the point of being nearly impossible. But I do it. And I do appreciate you taking the time to at least do it with me when you do. But you can all support the channel in your various ways, and I do appreciate it. These were some very interesting drops. And remember, all of this occurred yesterday, and we got them today. So, wow. That's where we are. But just thank you very much for being here. And Silenced, we got to talk tomorrow, Silenced. Thank you for being here and meant to talk to you today. But okay. Also, thank you to I Have Apophis for being here, Skip Jansen for being here, and Digital, thanks for being here. Heather Brown, Kayla, Amy, my mods, thanks for being here. Cromley, thanks for being here. Always Sweet Dude Shibby and Criminal Network, thanks for being here. Christina, thanks for being here, Christina. Everyone else, all you viewers, you know I love you. But hope to see you tomorrow. I hope to be back tomorrow, like I'm going to make an effort to. So hope to see you then. Hey, pray for yourselves and each other. And also pray for our beautiful country, United States of America, and for Abby and Libby. We love you. Love everyone. Like I said, stay warm out there. It's so freaking cold. Hey, snow down in Louisiana. What do you think about that? What are the odds? We're in the middle of our Arctic plunge. So hopefully that plunge will be removing itself and we'll get back to normal. but it's been extremely cold, and I got my dinner in the oven now. So we'll have warm dinner just momentarily. It'll be wonderful. So thank you all, and hug your kids, hug your wife, and if you're in Delphi, hide your kids, hide your wife. Also, uh, mm, I'll leave it. I'll leave it. Thank you all for being here. Good night.